I want to share a strategy that I used to use when I was doing defense work early in my career that would drive plaintiffs' attorneys crazy. You want to know what it was? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. Early in my career, I represented people who were being sued in car accidents and medical malpractice cases. And now, when I was defending these cases, I would have an opportunity to question the people who were bringing these lawsuits. That's known as a deposition or an examination before trial. It's really pretrial testimony, and it carries the same exact weight as if it is given at trial. The only difference is it's being done in your attorney's office and there's no judge and there's no jury present. So now when I had an opportunity to question the people who were bringing these lawsuits, there was typically one claim that they would often bring in these car accident cases especially, and that was that they were unable to have sex as a result of this car accident. And I would begin to ask them questions about their sex life. And the plaintiff's attorneys would go crazy. They would object up and down. And I say, what's the objection? Your client's claiming that they can't have sex anymore because of my client's actions. I'm entitled to probe and ask them questions. No pun intended. Yes, I am permitted to do that. So now I begin asking questions. Mrs. Jones, before this accident happened, how many times did you have sex? Objection, you can't ask that. Really? I can if you're making a claim that she can't have sex anymore. Okay, go ahead, counselor. Mrs. Jones, how many times a week did you have sex? And what time of day did you have sex? And with whom did you have sex? And where in your home did you have sex? Where else did you have sex? And what positions did you use when you had sex? And now, why am I doing that? To establish a baseline of what her life used to be before this accident happened. Now I want to see how the accident has affected her now. What problems she has today. Mrs. Jones, are you able to engage in sexual relations today? No, I'm not. Well, have you tried it this way? No, I haven't. And now, it's really embarrassing to ask this type of question, but I was doing it in a professional and a respectful manner. Now, if she didn't bring this type of claim, obviously I have no business asking these types of questions. But their attorneys would get so upset with me because I would now delve deeper and deeper and deeper to ask them all these probing questions about their sex life today. Well, have you tried it in this position? Have you tried using this lubricant? Have you tried using this sex device? And they would get so embarrassed. I say, listen, there's no way for me to know. I'm not in your home when you try and have sex. So I have to ask these questions because I don't know. And this information is not in your medical records. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into how these types of civil cases work here in the state of New York. You know, I recognize and acknowledge that you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.